Howdy, my name is Brian Foley. We're here to talk about Texas Rule of Evidence 409. It's offers to pay medical and similar expenses. So, this is similar to Rule 408, which banned the use of evidence of attempts to compromise with somebody, a way of settling the case. If you're going to make a statement to somebody to try to compromise or settle a disagreement, we want you to be able to make that statement and not have it used against you. This is along the lines of what we call subsequent remedial measures. Okay. So, Rule 409, here's what it says: evidence of furnishing, promising to pay, or offering to pay medical, hospital, or similar expenses resulting from an injury is not admissible to prove liability for the injury. Okay. So, the liability here, again, that means it's a civil case. It is going to be something where money only is on the line. This is not in the criminal context. And it's saying that the furnishing, promising to pay, or offering to pay the medical, hospital, or similar expenses resulting from an injury. You can't use that. Okay. But the commentary for this says something a little different. Why do we have this rule? First, it's to encourage people who, if out of the goodness of their heart, if they get in a wreck and they realize you can't afford, to pay for your medical bills and they want to pay for that for you, then they're allowed to pay for that without having that used against them in court. This really, I've never seen this happen. I can't find a case on it. It's very, very rare. But let's take a look at what the commentary says. All right. So the advisory committee notes is what we would call the commentary. These are for the federal rules of evidence. These aren't specific advisory notes for the Texas rules of evidence, but they're very, very similar, these rules, and they're generally construed by courts. They will look at the federal rules and the commentary or things that are being done in other states when we have a novel question. So let's look at 409. It says generally evidence of payment of medical, hospital, or similar expenses of an injured party by the opposing party is not admissible. The reason often being that such a payment or offer is usually made from a humane impulse and not from an admission of liability. And if they were to hold otherwise, it would, tend to interrupt. It would discourage people from being good if they wanted to be good, from being nice if they wanted to be nice. And the rules typically don't want that type of a situation to be created by the law. We don't want the law to get in the way of a good deed if it's going to be done. But let's look at the next part of it. And the last part of the advisory committee notes here says the rule does not extend to conduct or statements that are not part of the act of furnishing or offering or promising to pay. And the rationale they use is that to distinguish from Rule 408, where the conduct and statements would be excluded, it says that to reach a compromise, you have to make some kind of statement, but just to pay, you don't have to make a statement. So if you're going to pay, you're going to be nice about it, and you want to help somebody out, but you don't want to admit liability, then you just pay. You say, can I pay for your medical expenses? Would you let me do that? You can do all that, and it can't be used against you. So I hope this is helpful. I kind of doubt that it is, but if you're thinking about using Rule 409, you're in a very strange situation. I'd love to hear more about it. If you've got something in the comments, if you've ever encountered this rule, it is very rare to encounter it. But thanks for watching. And as always, these are just for educational purposes. If you need an attorney or you think you need an attorney, pick up the phone and call one so that you can get the advice you need from a real attorney that's listening to your specific situation. But I appreciate you guys tuning in. Don't forget to like and subscribe. Thanks so much.